Hi, good evening. This is an interesting Bombay High Court judgment. Citation is Reliance Industries Limited versus PL Rungta, Commissioner of Income Tax. Issue in this case is whether assessment orders passed in the name of amalgamating company after amalgamation is valid or not. That is the issue. Simply put, if X gets merged with Y, and after merger, if an assessment order is passed in the name of X, whether the assessment order passed in the name of X is valid. Because as per records, X is a non-existing company. That is the issue. Assessment year in this case are 1993-94 to 1995-96. ITO had knowledge of amalgamation of Reliance Polypropylene Limited and Reliance Polyethylene Limited with Reliance Industries Limited. But unfortunately, he passed the order in the names of Reliance Polypropylene Limited and Reliance Polyethylene Limited. Within bracket, he mentioned under the name, now merged with Reliance Industries Limited. That also he carefully mentioned. But orders, the name, first name is the merged entities, Reliance Polypropylene Limited and Reliance Polyethylene Limited. The matter went up to High Court. I need not have to narrate the entire story. So it went up to High Court. A jurisdictional issue was raised by Reliance Industries Limited. They relied on the judgment of Supreme Court in the case of Maruti Suzuki. In the case of Maruti Suzuki, it is a very famous judgment, so everybody may be knowing this. Supreme Court said that orders passed in the name of non-existing assessee is void ab initio. That is what the ruling of the Supreme Court in that case. Revenue relied on another judgment of Supreme Court in the case of Magagund Realtors. There, in the case of Magagund Realtors, the Supreme Court differed with the views of Supreme Court in Maruti Suzuki. In Magagund Realtors, the Supreme Court did not agree with the proposition that the proceedings taken against a non-existing company would be void. The Supreme Court observed in Magagund that unlike winding up, in the case of amalgamation, there is no end to the enterprise and it continues. The Supreme Court observed that courts have to see whether a successor or representative exists in relation to the particular cause of action upon whom the assets might have devolved or upon whom the liability in the event of adjudication would fall. So the court have to see that aspect also. That is what the Supreme Court says. But after saying so, Supreme Court did not dissent from the decision of Maruti Suzuki. So even though they express an opinion which is against the decision of Maruti Suzuki, Supreme Court followed Maruti Suzuki in Magagund. The Supreme Court held in Maruti Suzuki, that also we need to see again, that in spite of the fact that the assessing officer, after being informed of the amalgamating company, ceased to exist, as a result of scheme of amalgamation, and if the proceedings are initiated against the non-existing companies, then such proceedings are void ab initio. This line is very important. Although the amalgamated company participated in the proceedings, even if the amalgamated company participated in the proceedings, if the assessing officer is aware that that company does not exist because of its merger with the other company, but still passes an order in the name of the amalgamated company, Supreme Court says the order is void ab initio. Following that decision, Bombay High Court held that the orders passed by the assessing officer are void in this case. However, there is an interesting twist to this case. Bombay High Court clarified that nothing would preclude the revenue from initiating fresh proceedings against Reliance Industries Limited, that is the amalgamated company, in accordance with law for assessing the income during this period. The court did not agree that allowing the jurisdictional plea that is the orders are void ab initio, would deprive the revenue of assessing and passing the order in the name of Reliance Industries Limited on account of limitation. The revenue said, sir, if you pass this order, then we won't be able to reopen the assessment or assess their income relating to this period, 1993, 94 to 95, 96. They said limitation will apply and then we won't be able to pass the order. Court did not agree. Limitation will not apply. You can go ahead and pass the order. That is what the High Court says. My comments are, I have a few comments. One is, I am not sure whether the mistake of the assessing officer is inadvertent or intentional. I cannot comment on this. With this, I will stop. Point number one. Point number two. This order may be challenged before Supreme Court in view of the decision in Maruti Suzuki. There may be, because of the conflicting opinion, it may be referred to the larger bench also. That is also one point to be seen. Then the third point is, in my view, the order of the Bombay High Court is correct. In the sense, AO clearly knows that the company against whom the order passed did not exist. For this case, 93-94, it has taken 3 decades to reach the stage of High Court. So, if orders are passed recklessly, as again I said, as in point number 1, whether it is inadvertent or intentional, we do not know. The assessing officer will escape. He might have retired by this time. The company will escape. And just like that, they would have passed the order in the name of another company, and then they also did their job. Company also challenged it, and then they succeeded it. Huge amount of public income will not come into the kitty of the government. That is what my view is. Thank you very much. Have a great evening. Bye.